Good morning. So we had some filings come down yesterday. They're not too long. They're mainly responses, actually. Um, this first one is Wayfarer's response to Blake Lively's. Basically, she's seeking confirmation that Blake Lively's requests for admission are deemed admitted by operation of law. And Wayfarer have responded to that, which is in quite an amusing way. But it's another eye roller, as always. Like when we, see a Blake Lively filing, we're like, oh, right, okay, and roll our eyes once, and then we get the response, find out something's been misrepresented or it's not true, and then we roll our eyes for the rest of the day. So we'll just start. Dear Judge Lyman, defendants Wayfarer, etc., respectfully request that the court deny plaintiff Blake Lively's motion seeking confirmation that Miss Lively's requests for admission are deemed admitted by operation of law. First, Miss Lively is not entitled to have her request deemed admitted, as the response was timely served on November 13th, 2025, pursuant to the parties' November 7th, 2025 agreement. Second, Miss Lively's motion is unnecessary. It usually is. Although defendants objected to Miss Lively's 557 RFAs on the ground that they are directed to a group of 8 defendants rather than a single party, defendants have agreed to stipulate not only to the authenticity of the documents identified in the RFAs, but to as many trial exhibits as possible to streamline trial and avoid unnecessary litigation. Simply put, defendants have agreed to provide plaintiff precisely what she wants. Authentication, where possible, based on each defendant's personal knowledge of the documents identified in Miss Lively's RFAs. And they're probably at a point now where they've just agreed to give her what she wants because it saves Judge Lyman having to do it. And just to clarify as well, RFAs are essentially requests for admission. And in this context, basically, Blake Lively is seeking to, seeking the request for admission. She's seeking confirmation as to the genuineness of these specific documents. So I've had a few people say, "What are RFAs?" Which is, that's fine because it doesn't explain it for people necessarily, in these filings. Rule 36 of the Federal Rules of Civil Procedure provides that a party may serve on any other party a written request to admit, for purposes of the pending action only, the truth of any matter relating to b. the genuineness of any described document. On October 10th, 2025, the deadline for requests for admission, plaintiff propounded a single omnibus request to admit 557 individual requests. So that's the RFAs. Asking all 8 defendants to admit the genuineness of 557 documents and exhibits. And then we've got a footnote here. For instance, request number 104 lists 11 separate attachments, and 108 includes 8 attachments. And that's very important because it sounds like these are just 557 documents. No. In some cases, in individual documents, there will be a bunch of attachments. So, it actually is a lot more than than Blake Lively is kind of portraying it as. On October 31st, 2025, Plaintiff emailed defendants to identify 10 requests with typos that misidentified the documents. Defendants were being asked to authenticate. Plaintiff also advised that although 4 RFAs identified a single document with a single Bates number, so it's the same document 4 times, plaintiff expected defendants to consider it a single continuous document and authenticate all exhibits. Talk about quadruplicating work. Plaintiff has not provided any authority that permits amendment to discovery responses after they are served, not to mention after the deadline to serve the RFAs. In any event, defendants' responses were due on November 10, 2025. On November 4, 2025, defendants notified plaintiff of their objections to the form of the omnibus RFAs. However, to avoid needless litigation, defendants explained that we agree that the parties should stipulate to the authenticity of as many potential exhibits as possible to streamline trial testimony. Please let me know if you agree in principle to the concept of a stipulation on the authenticity, genuineness of particular documents. If not, please provide authority for the proposition that RFAs can be propounded to a group rather than to individual parties. On November 7, 2025, the parties met and conferred on defendants' concerns over the propriety of RFAs directed to a group rather than an individual party, based on that party's personal knowledge. Accordingly, defendants explained that they would object to the RFAs. However, defendants proposed that the parties work together to authenticate as many trial exhibits as possible to streamline trial, including the massive number of documents identified in the RFAs. We've got a footnote here. Footnote. It is difficult to conceive that plaintiff intends to present approximately 600 exhibits at trial. It's a lot. It's a lot of exhibits to prove claims that she's got currently no evidence of. Defendants explained they anticipated being able to authenticate certain categories of documents, including without limitation: 1. Communications on which a defendant is a sender, recipient, or copied. 2. Signed agreements and drafts of agreements provided to a defendant. And 3. Any document created by or provided to a defendant. Defendants noted that the RFAs included news articles or similar media releases that defendants probably cannot authenticate. So she's trying to get them to authenticate someone else's work. Defendants requested a 3-day extension of the November 10th response date on the RFAs to allow time to authenticate the documents listed in the RFAs, in the hope that the RFAs could be withdrawn, avoiding unnecessary litigation over the RFAs, which the Wayfarer parties deemed defective. Defendants also advised plaintiffs that they expected to authenticate further documents that might be identified as exhibits prior to trial, and similarly hoped the parties could work toward an agreement on the admissibility of as many exhibits as possible to streamline trial. Based on this discussion, plaintiff agreed to a 3-day extension of the due date on defendants' RFA responses to November 13th, 2025. Defendants indicated that if the task could be achieved by November 13th, 2025, they were hopeful that the RFAs would be withdrawn, thereby avoiding litigation over the form of the RFAs. On November 7th, 2025, plaintiff sent an email distorting the parties' positions at the meet and confer. Nevertheless, defendants immediately commenced a review of the documents identified in the RFAs. The task was complicated by the fact that the RFAs identified documents by base numbers only, requiring a search of the large database to isolate the documents. Multiple documents included attachments which needed separate review and authentication. Given these facts, defendants were not able to complete the task by November 13, 2025. Accordingly, the Wayfarer parties served their objections to the RFAs on November 13, 2025, the due date agreed at the meet and confer. Nothing in the objections or defendant's subsequent communications with plaintiff indicate that defendants intend to do anything but what they represented on November 7th. Review the documents identified in the RFAs to authenticate as many potential trial exhibits as possible. Nevertheless, plaintiff notified defendants that the extension for defendants' responses were conditioned on a stipulation to complete the authentication process by November 13th. Defendants' responses were untimely and therefore plaintiff deemed all 557 RFAs admitted and the reference documents authenticated. In a November 14th letter, defendants reiterated their commitment to streamlining trial and avoiding unnecessary litigation by authenticating as many exhibits as possible in advance of trial and working with plaintiff toward a stipulation on admissibility. Plaintiff conveniently fails to bring this letter to the court's attention. Well, of course she does. Defendants are continuing to work through the massive number of documents identified in the RFAs and are also identifying their own trial exhibits, which they will, where appropriate, ask plaintiff to authenticate. Most troubling is plaintiff's assertion that the Wayfarer defendants have made clear with their objections that they never intended, despite having the ability to substantively respond. The Wayfarer defendants have been perfectly clear about their objections to the form of the RFAs, namely consolidated requests to 8 parties are improper. However, plaintiff and the Wayfarer defendants will achieve the same goal by cooperating on authentication and admissibility. Finally, plaintiff will not be prejudiced by the alternative approach to authentication, which avoids the dispute over propriety of the RFAs. Trial is set for March 9th, 2026, leaving sufficient time for the parties to collaborate on evidentiary issues. Summary judgment motions were due on November 12th. Plaintiff did not move for summary judgment. Therefore, plaintiff will not be prejudiced by an issue relating to authenticity in connection with a dispositive motion. In sum, plaintiff's request all 557 documents identified in plaintiff's RFAs, plus attachments, should be denied because 1. Pursuant to the parties' November 7th agreement, defendant's response to plaintiff's RFAs was timely. 2. The RFAs are procedurally defective in that they are directed to a group of parties rather than seeking admissions based on an individual party's personal knowledge. 3. The RFAs are procedurally defective to the extent they were amended after service and after the deadline to serve RFAs. 4. Notwithstanding that the RFAs are defective, defendants have agreed to authenticate to the extent possible the documents identified in the RFAs, mooting any potential prejudice to plaintiff. And 5. Trial is set for March 9th, 2026, leaving sufficient time for the parties to collaborate on authentication and admissibility of trial exhibits. Respectfully submitted. Okay, so this is going to be, this is basically a case that boils down to why Lively has gone to be a diva to Judge Lyman and just complain about Wayfarer, and Wayfarer have come back and gone, really? She's got no standing to complain. And she's misrepresented what we said. So it's the usual tit for tat crap. We'll just see what Lyman says. Yeah, it's not much to say about that one. Okay, so this is the next letter, because Lively won her motion requesting that plaintiff be, like an order to compel production of documents. So Wayfarer have written a response to Judge Lyman. Okay. On behalf of Wayfarer, we write seeking clarification of the court's order regarding plaintiff Blake Lively's motion to compel production of documents identified on the Wayfarer party's supplemental privilege log of signal messages post-dating the beginning of litigation. The Wayfarer parties request 2 points of clarification. First, the court directed the Wayfarer parties to file a more complete log consistent with the order. Elsewhere in the order, the court directed the Wayfarer parties to provide an updated privilege log. The Wayfarer parties understand that the court has directed them to serve an updated privilege log and respectfully request that the court clarify this point. Second, the order directs Wayfarer parties to supplement their privilege log to indicate the senders of the signal messages logged. Many of the logged message threads span multiple days or weeks. Consistent with the joint ESI stipulation and order, when collecting and compiling the signal messages for privilege review, the Wayfarer parties divided these threads into 24-hour segments rather than into individual messages. Each 24-hour messaging segment may incorporate numerous messages sent by multiple parties, making it impossible to separately indicate the sender of each individual message. Viewing the order and the ESI stipulation and order together, the Wayfarer parties understand the order to direct them to indicate each of the parties who sent messages, as well as those who merely received them. For each 24-hour segment, the Wayfarer parties respectfully request that the court clarify this point so they can fully comply with the order. So that's pretty straightforward. Just clarify something. There's not much to say on that. Okay, on to the next one. This is from Blake Lively. And she's looking for an extension to amend the briefing schedule. Okay, and this is in relation to spoliation motion. Dear Judge Lyman, in accordance with Rules 1D and 2K of Your Honour's individual practices in civil cases, Plaintiff Blake Lively respectfully writes, with the consent of the defendants, Wayfarer, etc., and third-party defendant, Jones Works, to inform the court that all parties have agreed to modify the current briefing schedule related to Ms. Lively and Jones Works' respective motions for spoliation sanctions, due to the Wayfarer defendant's untimely filing and service. Under the current briefing schedule, the deadline for Ms. Lively and Jones Works to file any reply briefs in further support of their respective motions is December 5th. Under the parties' agreement, the deadline to file any such reply briefs shall be December 8th. The parties' next scheduled appearance before the court is December 9th. Okay. So they've just basically agreed to allow Stephanie Jones and Blake Lively a few extra days to an extension to reply to Wayfarer's response to both Jones Works and Blake Lively's their opposition to the motions from both Jones Works and Blake Lively, the spoliation sanctions. So instead of seeing the replies on the 5th of December, we will now see them on the 8th of December. Untimely filing and service. I'm curious about that. We might have a look to see what they're referring to there, because everything appeared to come down in time. I didn't see anything untimely. But that's just I really wasn't looking for it though either, so it maybe something got filed late, and they're basically saying, look, I tell you what, instead of us kicking up a fuss with Judge Lyman, how about you just give us a few extra days to respond? And for the sake of a couple of days, it's a lot more simpler, efficient, and economic for Wayfair to say, yeah, fine, no problem. I mean, it's not like it's a rush anyway. So, okay. I mean, here's the certificate of service for the opposition to Blake Lively's spoliation motion, sanctions motion, and all the exhibits, which is dated November 20th, that was the deadline to respond. So I'm not quite sure. I'm not sure. And just for the sake of completeness, this is the certification of certificate of service that Jones Works was also served on the 20th of November. So yeah, I am confused, but I've not looked for anything, and I'm not going to look too deeply into anything. I'm sure someone will pick up what they're talking about. But either way, I mean, it's not important because Wayfarer have agreed to this, so it's going to happen. Judge Lyman is going to stamp it and say, yeah, it's fine, because they've all agreed. And then, although I am actually going through these letters in order of what was filed first, I very nicely landed with this one, which it's fantastic. So effectively, I did save the best for last, but that just happens to be coincidental because it was also the last one to be filed. This one is Wayfarer. So I don't know if you remember yesterday. So Blake Lively has filed this ridiculous letter supporting Stephanie Jones in a motion to compel Katie case because Blake Lively's like, well, I'm entitled to that discovery too, right? Even though it's not even the same case, and she's not a party in the Jones case. There's no mention that she'd even served a subpoena for these documents, but Blake Lively's like, well, I was entitled to they're responsive to me, and for some bizarre reason, she just filed this ridiculous letter saying, well, you should compel Wayfair because if Jones can prove that she was smeared, then I can tell the jury, look, Melissa Nathan, her credibility, that she smeared me too. And she's basically acting a bit parasitic, I think is the term. I feel like it's being a parasite here of Stephanie Jones may get something that might prove her smear campaign, and because Blake Lively is still searching in the dark for evidence of her smear campaign, and has gone to the ends of the earth and still can't find it, she's like, oh well, and someone else's will do. And we saw Maxwell Breed, the attorney for Katie Case, come out and say, well, hold on a minute now. This letter that Blake Lively's filed suggests that we owe her something. We didn't produce something. That's bullshit. It's basically what he said. She's not entitled to anything. Wayfarer have followed suit. And basically they're now holding hands and skipping down the school play yard with Maxwell Breed and going, hold on a minute, Judge, before this hearing we've got in 2 days' time, because that's on Monday, about all this, let's just make sure all of this shit is in front of you on the docket. And I love this letter. I really love it when they get snarky, but and we always find out the other half of the story that Blake Lively never tells us. So I'm going to go out with this one. Dear Judge Lyman, as counsel for Wayfarer, etc., we write in response to the recent letter from plaintiff Blake Lively, submitted in support, they put quotation marks around support, of Stephanie Jones and Jones Works motion. In another case, to compel non-party Catherine Case to produce certain documents in compliance with a subpoena. Miss Lively has filed a robust letter in support of a motion filed by another party in another case in which she is not a party. I'm adding the emphasis here of the italics. Sorry, I'm hoping it's working. I'm going to start that line again because it was good. Miss Lively has filed a robust letter in support of a motion filed by another party in another case in which she is not a party to compel compliance with a subpoena that she did not serve. Miss Lively lacks standing to enforce the subpoena to Miss Case because she did not serve it. For that reason alone, the court should disregard Miss Lively's letter. And I'm just going to point out some irony here because I can do this. Because I have standing. When we filed, myself, Lauren, Cassidy, Ashley, Kens, when we all filed our motions to quash subpoenas that were served on X, that were served on Google, that were served on, well, TikTok wasn't one of ours, but you get the gist, yeah? They were served on the tech companies for our data, not for the tech companies' data, for ours, right? And quite intrusive data, bank accounts included, no less, honestly. When we highly offended and opposed to our data being handed out willy-nilly to Blake Lively for a case we are not a party in, have nothing to do with, because the tech companies weren't going to do it, we took it upon ourselves to say, hold on, no. We filed motions to quash, and Blake Lively then turned around and said, well, hold on a minute. We didn't serve you. You lack standing. She withdrew them because we also we filed 30-page documents each, just absolutely taking Blake Lively apart for all the reasons we don't believe her, all the reasons why we think she got the bad press, her piss of the marketing, so on and so forth. And it clearly was not a good look. It was not probably, well, it was almost certainly something that Blake Lively did not want on the docket. And we also told a few extra home truths, got evidence in that wasn't already, we got references and links to evidence, such as the Ari Emanuel tape. In my case, I put that into my motion to quash, and that hadn't been previously mentioned or brought to the court's attention. Now suddenly it was. And Perez, when he did his, he put in my entire motion to quash, and I think Lauren's letter. Lauren wrote a subsequent letter. So it all went back in again. And we very much joined forces as a community to say, no, this is not okay. But for her then to, it's perfectly fine for her to insert herself in a lawsuit that she's not involved with, that she has not been served a subpoena and has not served a subpoena, and then sit there and go, no, I support it. And by the way, I want the evidence for myself. It is the constant hypocrisy around this woman, and what I see day to day is unrelenting, absolutely unrelenting. And it's what really gets my goat with this lawsuit is she's not trying to play fair within the rules. Yeah, okay. If you want to be black and white about it, technically a lot of it, not all of it, a lot of it is within the rules, right? Or there's not a rule there to say she can't do it, but it's definitely unethical and immoral. But there are times when, like in most litigation, the two opposing counsels will try to be fair. And I don't see any attempts by Blake Lively or her counsel to do that at all. And that annoys me. Because if she had a genuine case, she genuinely felt vulnerable, then this just does not strike me. The actions just do not strike me as someone who believes in their case. This is just getting scrappy, and like several motions now just to say, don't let them testify. Issue an order, Judge Lyman, that I'm right, they're wrong, and by the way, they can't say anything. Literally put a zip across their mouth and shut it. And it's annoying. It's annoying to keep seeing these tactics. Anyway, I'm not going to climb down off my soapbox. Okay, so the crux of Miss Lively's contention is that the documents sought from Miss Case are needed to discredit Melissa Nathan because, according to Miss Lively, Miss Nathan's deposition testimony cannot be reconciled with Miss Case's deposition testimony. Miss Lively does not explain how any difference in the testimonial evidence concerning Stephanie Jones' leaks or any other website is relevant to Miss Lively's claims or defences thereto. Moreover, the use of discovery to establish credibility and gather information for impeachment is limited, especially when the witness, Miss Case, is a non-party. Ms. Lively further argues that the alleged existence of documents concerning websites or social media posts relating to Stephanie Jones confirms there are documents responsive to Ms. Lively's document requests that were improperly withheld. Yet Ms. Lively neglects to explain, let alone demonstrate. Sorry, I'll start again. Yet Ms. Lively neglects to explain, let alone demonstrate how that is true, fails to attach her own document requests, and confusingly cites to a subpoena that she did not serve. The Jones Works motion to compel should be denied for the reasons set forth in the submissions properly filed by Miss Case, as well as by Wayfarer Studios. Well, Wayfarer, etc. Okay, but that's just a really great way for my day to continue now, so I'm in a good mood. All right. So we probably won't be much more before Monday. So take care, guys. Have a great weekend, and thank you for your support. And please do take a moment to like the videos and subscribe to my channel. If you're able to hype, it will always help out my channel. And I appreciate everything from all of you. Thank you very much. Take care.